Did it? Welcome to the morning session of the Kansas Court of Appeals. I'm Karen Arnoldberger, the Chief Judge of the court, and I'll be presiding over the proceeding today. With me is Judge Stephen Hill, the longest-serving law-trained judge in the state of Kansas at this point. And also joining me will be Judge Patrick McEnany, who serves as senior judge for this court. I will call the case in just a minute, but I'll remind the parties that we have read the briefs. We are familiar with the facts in the case. You have 15 minutes each to argue. The appellant will be allowed to reserve some time for rebuttal if he chooses. So with that, I will call the case 122-222, State of Kansas versus Markale Martinique Walker. Would the parties state their appearances, please?
May it please the court, Richard Ney for the appellant, Markale Walker.
Thank you, Your Honors. May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present ready for argument.
Thank you. Mr. Ney, did you wish to reserve any time for rebuttal?
Yes, Madam Chief Judge, if I could reserve 3 minutes, please.
Okay. Make a note of the time here, and then you can go ahead and get started.
Thank you, Your Honors. There are a number of issues raised here in our brief. I'd like to start with issue 4, if we could. That the defendant's convictions for both aggravated battery and attempted second-degree murder are multiplicious. We've cited in support of that the Appleby case. That's a capital murder case from the Kansas Supreme Court, where the underlying element to make the defendant eligible for capital murder conviction was an attempted rape. The court there said attempted rape under those circumstances was not a separate offense. It was part and parcel of the offense itself. In fact, as the court wrote, it was necessary to prove the elements of capital murder. The state had to prove beyond a reasonable doubt that Appleby intentionally, with premeditation, killed AK in the commission or subsequent to the crime of attempted rape. Here, the state charged attempted murder, attempted first-degree murder. My client was convicted of attempted second-degree. The overt act alleged here was, in fact, the aggravated battery, the same exact facts. The state in its information charged as the overt act in count 1 that he did commit any overt act, to wit, shooting RMP in the face toward the perpetration of a crime, to wit, murder in the first degree. So,
counsel, let me interrupt you just a second, because I'm intrigued by this argument a great deal. Aggravated battery, to commit aggravated battery, you don't have to have an intent to kill.
No, you do not.
To commit murder, though, you have to have an intent to kill, correct?
Yes, Your Honor.
So, also, if I shot at someone and missed, I could be convicted of attempted murder, correct?
You could, Your Honor.
But I couldn't be convicted of aggravated battery because I missed.
No, you could not.
All right. So
the question would be, could you be convicted of aggravated assault?
For multiplicity purposes.
Right.
For multiplicity purposes, don't they all have to line up? Because what we're talking about here is the same conduct being charged in different ways. Isn't that the real problem?
Well, it is the core problem, but let's look at Appleby. You don't have to commit a rape or an attempted rape to be convicted of murder. Of course not. But when you use that attempted rape as the predicate for the capital murder, the Supreme Court said, and Appleby said, it's part of it. When you use as the overt act, as the jury was instructed here, the shooting in the face, which is the aggravated battery, that again, it is part of that. I mean, we could, and frankly, there are constitutional ramifications. We get these identical elements arguments, and sort of it's like the law school debating society. You know, what is this and what is that? But why did the state stop here? Why couldn't the state also have charged here, not to give them ideas, but with a level 7 aggravated battery, which is an aggravated battery or battery committed with a deadly weapon. Now, you don't have to have a deadly weapon to commit an aggravated battery for great bodily harm. You don't. And you don't need to create great bodily harm. You could just graze someone to commit a level 7 aggravated battery. Well, why not that too? Let's add that on. The problem here is we are getting deep into the weeds of constitutional problems. The double jeopardy provisions of the U.S. Constitution, Section 10 of the Kansas Constitution, as the courts have said, prohibit punishing someone repeatedly for the same offense. My client here got 63 months for the attempted murder, 61 months for the attempted murder, and got 43 months on top of that consecutive for the aggravated battery, which the state admits in its brief is exactly the same offense. The state on page 39 of their brief says, to be clear, while defendants' convictions for second-degree murder and aggravated battery arose from the same conduct. They said they are not multiplicious because each offense requires an element the other does not. Well, one, where do we get off in the constitutional train on that to keep repeating? I mean, again, let's add ag battery 7. But secondly,
excuse me, Ms. Benet, don't we get off on that path because the Supreme Court kind of changed position of late and said we look at an elements test, and aren't we required as an intermediate court of appeals to adhere to what the Supreme Court says?
Well, you are, Your Honor. But here, because the uniqueness of the issue of attempted murder, the state must allege an overt act. The overt act they alleged here was the crime. So like in Appleby, the offenses here included an identical element. The identical element of attempted murder, the overt act, was the aggravated battery, which the state admits. It's the same conduct. So we are in different positions than in most of the cases that the Supreme Court has dealt with, except Appleby.
Let me ask you one more question on this, because I know you want to talk about other issues as well.
I did.
But so if you shoot someone and don't kill them, you can only be convicted of the battery, the aggravated battery, or you can only be convicted of the attempted murder and not the aggravated battery. Which is your argument?
My argument is that the attempted murder contains the element here of the aggravated battery. It's the overt act towards the commission. That's how the jury was instructed. It's right there. Shot him in the face as the overt act. So here, he could be convicted of the attempted murder, but not, and he could be convicted of the aggravated battery, but they're multiplicious. They, in a sense, merge because it's an element. Appleby couldn't be even clearer if you've got an attempted rape, which has really nothing to do with the homicide itself. But if that's the predicate element of the capital murder, Supreme Court has looked at that as the same offense. And this court must apply the Supreme Court's law in Appleby. You're not going against the Supreme Court, you're following the Supreme Court when it looks at the case here. If there are no other questions on that issue, I'd like to turn to the juror issue, where the juror PA or prospective juror PA was dismissed without a hearing, without presenting anything to the court, sort of off. Yes.
Let me ask you a question, because I want to make sure I understand the facts here.
Yes.
This, I take it, it was a woman. She was selected on the jury. The jury wasn't sworn in.
Right.
She tells somebody, I can't make it tomorrow morning. Trial starts the next day, tomorrow morning. She doesn't show up. Somewhere along the line, the judge dismisses her and puts in a alternate juror, and they're all sworn in and the trial proceeds. is there anything in the record that shows that the judge talked to this juror?
No, in fact, the judge's aide, which we would argue is the same thing as the judge, talked to the juror out in the hallway. Now, again, as Judge McEnany knows, you can have important pieces of opera take place off stage and people sing about it later. You can't do that at trials. And what happened here was that they recessed for the day. The judge's aide has a conversation with juror PA, comes, relates some things, and we submit that's the same as, it's an ex parte conversation with the juror, whether it's the aide or not.
All of this is done before the trial starts.
Yes. Yes. And I wanted to see sort of one thing you said, Judge Hill. She does not just not show up. It's not a question she doesn't appear. Here's what happened. She tells the judge's aide that night before the morning, I've got to take my mother to a doctor's appointment. And then she is told by the judge through the aide, and I'm quoting from page 234, 235 of volume 16. All right, we'll just tell her that she needs to see if there's anybody else who can take her mother to the eye appointment. And then 2, she needs to get here as soon as that eye appointment is over, as soon as possible. She is told she can go, but get back as soon as possible. The aide relays that could take maybe 2 hours in the aide's opinion. We don't know where that information comes from. Trial starts at 9:30. Ideally, she should be there at 9:30. She's dismissed at 10:09. So everybody knows it's unlikely she's going to be there, and the judge gave her permission not to be there. When asked about this whole issue, and then it goes into how much did she sleep and what have you, which the judge does an independent investigation of by calling her employer, which, again, we don't understand. When all that is done, the defense counsel that time, Mr. Sylvester says, I don't wish her removed from the jury, but I guess we'll have to see her position tomorrow. So the whole thought is she's going to be there tomorrow and they're going to deal with it. Well, instead of that, at 10:09, before she's even expected to be back from the eye appointment, and after given permission by the court to go, the judge removes her over the defense objection, the clear objection, without ever questioning her about her ability. Things are gone to ability English, her employment, her sleep, what have you. Nothing is done except, if you will, off stage.
Can I ask a question here, Mr. Manny? This alternate was selected as a juror just like all the other jurors were selected, correct? Nobody knew she was going to be the alternate until the judge says, here are our alternates, right? They didn't select alternates separately from the rest of the jury, did they?
They did not in this case.
Okay. So do we need to be concerned about what's the prejudice here? I mean, you've got one juror that was approved and another juror that was approved.
Well, yeah, an African-American juror was excused. She was African-American.
We don't have a Batson challenge here.
Well, how could you have a Batson challenge when it was done by the court sort of off stage?
But clearly for reasons unrelated to her race. I mean, it had to do with whether she was there and whether she had enough sleep. She was the one that was kind of insinuating that she couldn't comply with her obligation as a juror. I
disagree. There is never even a report from the aide. And again, no question on the record is ever done. Let's remember.
Okay, so let's get
There's
back
not even a question from the aide.
Is there a requirement? Let's get back to my question.
Okay.
Is there a requirement that she be that your client be prejudiced somehow by this?
No. How could you ever determine that? How could I, if a judge has said, I don't like the way those two jurors look over there, I'm taking them off and substituting alternates. How could I ever prove I'm prejudiced? How could I prove that those two jurors would have acquitted? I can't. So prejudice is not an issue here. What we have here is a constitutional violation, the offstage violation, the fact it was done where my client was not present, when in fact his counsel, although asking to question her, was not allowed. We have also a problem, Your Honor, is we talking about alternates, et cetera. There were no alternates. This jury had not been sworn, as Judge Hill pointed out. The statute says, and as we noted on our reply brief, the statute requires that you can substitute an alternate to replace a juror who, prior to the time the jury retires, to consider its verdict. They're not sworn. How are they jurors? And we put our definition of what a juror is. You have a clearly other problem here, is you're using a statutory procedure, which certainly says the judge was abusing his discretion if he went against the statute, that doesn't allow this at all. You can't say, oh, I'm substituting this juror for this prospective juror without any input or objection, if you will, from the defense. Because the statute says you have to have a jury and then you can substitute. That's not what happened here. And I think my time is probably up. But I would just say, and one more
30 seconds. Yeah.
Thank you. I appreciate it. One more piece of this is, there was a clear objection from the defense, and I want to make that clear. Mr. Sylvester asked on the night before, I want to talk to the juror. I'm not agreeing. He said the same thing the next day. And even the judge had sent, when the motion for new trial was made, said, well, I guess we could have questioned her. I mean, that's the key. That's one of the keys here of the problem, that this was done ex parte. It was done outside the presence of the defendant.
Okay.
Thank you. I'll reserve my time.
You still have your rebuttal time since we asked a lot of questions. Go ahead, Mr. Gillette.
Thank you, Your Honor. I'll take the issues in the same order unless this court would direct me otherwise. I think I can be pretty brief on issue 4. The issue in Appleby is exactly as the state sets forth in its brief. The capital murder statute requires that the killing occur in the commission or subsequent to the commission of rape as defined in the statute. So to be convicted of capital murder, the state did have to allege and prove that the killing occurred during all of the elements of the rape being committed or following all of the elements of a rape being committed. That simply is not the case here. We did not charge the aggravated battery as the overt act. We charged a shot to the face. The aggravated battery as charged was a question of fact for the jury. They could, this victim was shot twice. We relied on the single shot to the face as the overt act in support of the attempted murder. As Judge Hill pointed out, the aggravated battery does not require evidence of any intent to kill. And I would also note in our brief, we are clear that the aggravated battery, or that the murder also requires no evidence of great bodily harm. An attempted murder requires no evidence of harm at all. A shooter can miss, and we would be fine. Or in this case, the shooter could hit someone, and they miraculously happen to survive. And again, this is not a multiplicity issue. If there are
only look at elements now, hasn't the Supreme Court shifted gears? It seems to me several years ago, this conduct would have been problematic, but now we're supposed to look at the elements, correct?
That's my understanding as I set forth following Schoonover and the subsequent cases. For purposes of both double jeopardy under the Fifth Amendment and the Kansas Constitution, we look at whether it's the same course of conduct, and then we look at strictly at the elements. And here, the defendant cannot meet the strict elements test that's required to demonstrate multiplicity.
And are we bound to follow the Supreme Court's lead on that?
You are, Your Honor. This court, as an intermediate reviewing court, is bound to follow our Kansas Supreme Court precedent. If there are no other questions on issue 4, I'll shift to the first issue. And to be perfectly frank, I'm not going to dive into the merits or potential merits of the issue at first, because there's a serious preservation problem here. I understand that opposing counsel would like to cast this record as something other than it is, in saying that there was a timely and specific objection to how things were handled. And as he suggests in his reply brief on page 5, with citations to the record, claiming that there was a specific objection or wanting to hear more from this prospective juror, he makes 2 citations. And I want to be clear about the facts. As Judge Hill was asking, after the full jury, the prospective jury, all 13 members were winnowed down, or the chaff, as I guess would be an appropriate way to characterize it. All of the others had been dismissed. We had the 13 that were going to hear the evidence in this case. As those people were leaving the courtroom, juror PA made a mention that she had some difficulties and wanted to bring that to the court's attention. That's consistent with how the court instructed the jury to raise issues should they arise. There is a brief conversation in the hallway, and what is critical here, and I think I even heard opposing counsel mention this morning, what's critical here is a hearing. At that moment, the district court offered defendant a hearing on the record with Ms. Limmer and or with juror PA. The state was clear and clarified prospective juror PA was still present. So if there was some further process to be had, that was the opportunity. And defendant did not take it. He rather instead just says, I'll just wait and see what happens tomorrow. We'll just wait and see and let the chips fall where they may. And then she doesn't show up. And the question is, so then what is the court to do? And they proceed in the manner that they did on the record here. This is absolutely not preserved. Again, defense counsel didn't even ask to hear more from juror PA until after she didn't show up. The chance was abundant, was clearly offered. As to the issue of preservation, the state raises in its brief that this is a new claim, trying to stretch what was a very generic claim, I just want to hear more from her, into this constitutional or ex parte challenge that the defense does here. It's a new argument. Defendant failed to brief how he can do that. He tries to cure that with a reply brief, but with all due respect, I don't think that is an appropriate way to try to address preservation, because it allows the defendant to open a door to raise new issues regarding preservation for the first time in a reply. It allows the defendant to escape page limits, and it also allows the defendant to, had he not replied, come up with whatever basis he could concoct today for this court and the state to have to address from the bench. As for the allegations that are set forth, whether this arises on settled fact, it's a question of law arising on settled facts. The facts are not settled. Defense is the entire foundation for their new argument is that there may be more facts to be heard, or may be more facts to be considered. The simple fact of the matter is, if this does arise on settled facts, then those facts are as the state set forth in its brief, and the defendant is absolutely not entitled to relief.
Mr. Gillette, let me ask you this. It is clear, though, from this record that the judge excused this prospective juror outside the presence of the defendant and probably defendant's counsel and probably the state's counsel. Is that correct?
I don't think that is exactly correct. I don't know from this record whether this juror was actually excused by the district court, except for the fact that she did not show up And then the court made the record that we're going to proceed with the 12 that are here. So if your honor is implying that there was some kind of a conversation directly with juror PA telling her, you are excused, don't come.
No, I'm not asking. I'm just, somewhere along the line, you went with 12 other jurors, and this one, juror PA, wasn't on the jury anymore.
Right.
Somewhere along the line, she got dismissed.
Right.
And was that done not in the presence of the defendant and defense counsel and probably even the assistant district attorney?
So I think that the dismissed is probably a more accurate way to address it, to describe it, than excused. And this did happen on the record. The fact that the court was going to proceed and excuse her or dismiss her, excuse me, but that she was dismissed, that happened on the record in defendants present with defense counsel there.
Is that unacceptable or is that unreasonable?
I don't believe that it was on the facts of this case. And on the facts of the record as it currently stands, I don't think that was unreasonable. So here's the only thing. There was a conversation with her employer that the defendant complains about. It's not clear exactly when that happened. It is not clear. There is no indication that juror PA ever had any further contact with the court or the court had any contact directly with her. There's no indication that juror PA ever showed up. Or ever reappeared. There's also a clear problem here, and I'll get to it eventually when I talk about harmlessness a little bit more. There was not only the appropriate remedy at the time that it became clear juror PA was going to have an issue. This could have been addressed at a post-trial motion. It wasn't. The defendant never summoned juror PA or Miss Limmer. Never subpoenaed them to try to have them testify, to present a hearing. But anyway, I'll just briefly, before I go any further, when we start talking about preservation one more time here, the argument that I guess I try to glean here is that this somehow touches on a fundamental right to a jury trial. I don't know how that right was violated here. The defendant had a jury trial with 12 jurors that were perfectly acceptable to him. There's no violation to even complain about. So I'll turn to the harm, and with all due respect to opposing counsel, it's absolutely incorrect. There has to be some indication of harm here. This is an error correcting court. There has to have been an error to merit relief. There is none here. There is no indication that there was any harm. There's every indication that there was no harm here. And just briefly, again, I don't think that it is clear that defendant even briefs or argues what further process he was entitled to. I still have not heard that process laid out today. There were options, certainly. He elected to take none. I also don't hear any articulation of harm, just a vague allegation that, well, no, suddenly now I don't even have to have harm. That's simply not true. This court has harmless error tests, even for constitutional violations. And I think that test is met and exceeded here, even if we were to assume some form of error. The factors, I guess I'd just briefly touch on, they are set out in the state's brief at page 23. The overall strength of the state's case, I point out the state's case was strong. Whether either party objected to the manner in which the judge handled the communication, while defense would characterize that one way, I think it's pretty clear. There was no specific objection to how this was handled, only that the defense counsel made a half-hearted, after the fact argument that, oh, I want to hear more from her now that she's not here. So it's a non sequitur argument at the district court level. Whether this was some kind of a critical aspect of the trial, absolutely not. This was pre-trial. This is pre the defendant receiving a trial by jury of 12 jurors that were perfectly acceptable. This is something extraneous that was going on with juror PA. It made it difficult for her to serve. I don't know why it didn't come out in voir dire, but the simple fact of the matter was it was an innocuous conversation. It's not akin to the McGinnis case that the defense cites in their reply brief, where a district court actually made a substantive communication to a sitting jury about why a state's witness didn't testify. This is a world apart from that. And then again, I come back to the ability of a post-trial remedy to mitigate the error. Why, if this is such a earth-shattering issue, there should have been something more than just a half-hearted recitation of what was originally a half-hearted objection in the first place, simply to wanting to hear more directly from PA before she was dismissed and the trial proceeded. I don't even think that the defense identifies harm again in their brief or here today. I don't think this court should entertain this issue at all, but should it, it is utterly meritless, as the state has set forth and argued. Briefly, if I may as well, Chief Judge, I don't know how much time do I have left? I'm sorry.
About a minute.
Okay. I'll just briefly, I don't think the second issue is preserved either. There's a requirement for a timely and specific objection regarding hearsay. Didn't happen here. And then as far as the prosecutorial misconduct allegation, respectfully, that is yet another mischaracterization of the record. The prosecutor's argument in this case was absolutely appropriate. I would welcome any questions on any issues that I've discussed or any of the other issues in the brief if this court has them.
Thank you. Any questions from the panel? Mr. Ney, rebuttal. And before you start, I want to start with one question.
Certainly.
Counsel raises a question: what further process was the defendant entitled to here? If the defense counsel was given an opportunity to question this juror the night before and didn't, how do you think this should have gone down?
Well, he wasn't given an opportunity to question this juror ever. Let me read you the transcript of what the judge said the night before. All right, the aide gives her statement. All right, anybody want to make a record or anything having to do with that issue? And the prosecutor then says a bunch of things, and defense counsel says, and here's the entirety of the defense counsel, I do not wish her removed from the jury, but I guess we have to see what her position is tomorrow. So, and then the judge says, all right, we'll just tell her she needs to be back after the appointment. So clearly he's being told there's going to be a questioning of her tomorrow. That's what he's asked for. Then when she's not there, the record is very clear. He again asks, we've got to question her. The judge has done independent investigation by talking to the employer, but repeatedly he asked for that. I don't know what Mr. Sylvester should have done to preserve this more, because then the judge acknowledges when the jury is being impaneled, the judge says, quote, other than the objection that has been noted here today, he's talking to Ms. Sylvester, you accept the jury as summoned, selected, and impaneled. And defense counsel responded, yes, other than the objection. The objection was to what happened with juror PA. Mr. Gillette wants to argue, apparently, well, there's no prejudice. Well, why? How about this? Let's have the defendant excluded from jury selection. He's just not there. We don't think that he's going to add anything. And where's the harm? Is that okay? Just, we have a couple days of jury selection. We don't need the defendant. Of course, no one says we have to prove the harm. How do I prove the harm? You've denied him his ability to be present. A juror was struck based on information no one heard except the aide or the judge when he contacted the employer. That is not okay. That does violate fundamental rights. And again, where do we have to show the prejudice? How about excluding him from the whole trial? How would I have to, what prejudice could I show? Well, what was he going to do? What was he going to say? That's never been the requirement of this court or any other court. So this was preserved. Mr. Sylvester objected to the jury as a whole. He repeatedly that day said he wanted to talk to the juror. The following day, he said he wanted to talk to the juror, and he objected to the excusal. I'm not sure, except lighting himself on fire, what more he could have done to prevent this. And turning for 1 second to the issue of the multiplicity, you know, we have an absurdity going on here. Again, tell me how every aggravated battery with a gun, unless it's a scratch, but where a bullet penetrates the body, is not both a level 5 and a level 7. The elements are different. So you're telling me we can stack sentences for one bullet in every aggravated battery case where a gun is used. That becomes nonsensical. And I don't care, we can talk about elements tests, we can talk about whatever else we want to talk about, but we need to be talking about the United States Constitution, which says you cannot have double jeopardy, and that is double jeopardy, and Section 10 of the Kansas Bill of Rights that says the same thing. But in this case, they decided to argue that the underlying facts, that is the overt act in this case, was the aggravated battery. They talk about 2 shots, and that is not what the jury is instructed. In fact, in the state's own brief, they say it's the same conduct. Look at page 39. They admit that. Thank you. I have nothing else unless there are other questions.
Anything further from the parties, from the panel? Okay, thank you very much for your arguments today. We'll take this matter under advisement, get an opinion to you as soon as possible. Thank you.
Thank you.